Turn off the phone. Turn it off. Turn it off.
All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Beth Myers presiding, is now set. Please be seated.
Good morning. Welcome to the First District Court of Appeals. We have two cases to be argued this morning. You will notice that Judge Krause is not here today. She has given me permission to let you all know that she has come down with COVID and so needs to remain at home isolated. She is going to be watching these arguments by YouTube, and she will be fully participating in our deliberations. She's sorry that she cannot be here today, but we will proceed with Judge Krause participating by watching the oral arguments and then deliberating with us. The first case on the docket this morning is In Re NS. Ms. Bailey is here on behalf of appellant. Mr. Sims is here on behalf of appellee.
Good morning, Your Honor.
Good morning. Ms. Bailey, as appellant, you will have 15 minutes to argue. Would you like to reserve any of that time in rebuttal?
Yes, Your Honor, I'd like to reserve 5 minutes for rebuttal.
All right, I will keep your time, and whenever you're ready, you may step forward and begin.
Thank you.
Good morning, may it please the court. My name is Donyetta Bailey, and I represent the appellant, Angela Shamel. This case is essentially about a father who objects to grandparent visitation with his biological father because he doesn't believe it's in the best interest of his children. When the court considered the grandfather's petition, they did not adhere to the legal standard. I have three major points that I want to make this morning. The first one is that the juvenile court's order, she did not give special weight to the father's wishes as required by the U.S. Supreme Court. She switched the burden of proof from the grandfather to the father in contrast to Ohio law. And third, she made factual findings that were against the manifest weight of the evidence. I want to start with the first assignment of error, which is that she failed to give special weight to the father's wishes, and I want to elaborate on why the U.S. Supreme Court has held that is important. According to the U.S. Supreme Court, parents have a constitutional right to due process, and under the 14th Amendment, they have the right to make parenting decisions concerning the care, custody, and control of their children. And that was the standard that was set forth in the Troxel case, which is in my brief. Ohio courts, the Ohio Supreme Court specifically, in Collier, has adopted this legal standard for all requests for non-parent visitation. In determining whether to grant visitation rights to a grandparent, the trial court is required to consider all the relevant factors in Ohio Revised Code Section 31.
Right, and I guess that's my question. Like, the court has to consider all relevant factors, and while the parent's wishes are accorded weight, like, it's not dispositive. So are you saying the court didn't consider his wishes at all?
Yes, Your Honor, that is my exact argument, is that in the First District Court of Appeals case with this court, you all said that, yes, you give the parents consideration special weight, but you also balance that against the other factors. My argument in this case is that the juvenile court did not give the father's wishes any weight at all. And there's evidence of that throughout the record. First, she totally ignored his concerns about how the visitation with the grandfather affected the kids at school, and required my client to submit corroborating additional evidence beyond his testimony, and totally dismissed his testimony.
Well, I think there's a difference between ignoring concerns and saying, I don't think you substantiated your concerns as a factual matter. And so my question is are you quibbling with the factual determinations by the trial court, or are you saying that there was something that she just said, I'm not going to consider, and then you would contend that that's error?
Yes, she specifically said, I'm discounting the father's testimony and not considering it because he didn't bring in any additional evidence to support his testimony and disregarded his testimony completely. And she says that essentially in the record in her order. Father testifies that the kids had to seek counseling. She goes, but there's no other evidence in the record to support that, so I'm discounting it completely. She said the father testified about how the kids' grades declined when they moved with the grandfather. She said because he didn't bring in anything to actually prove the grade, she's discounting his testimony completely. And my issue is,
Follow up with, excuse me for interrupting you, but.
Yes, Your Honor.
When you say she discounted it, following up on Judge Bergeron's question, does that mean that she just found it not credible, which is a determination for the trial court, or are you saying she refused to consider it at all?
based on the wording of her order, Your Honor, my argument is that she refused to consider it at all. She didn't say, hey, I weighed the credibility of his testimony against.
She did. She said the court does not find father's witnesses in this trial to be credible. The court does not find father's description of the children's relationships with grandfather to be credible. So she's making credibility findings in this order.
Well, yeah, but not at the point where I am as far as why she did not give the father special weight. So there are certain circumstances throughout the order where it was a credibility factor, but this isn't it. If you look, Your Honor, at the specific language that she uses when she talks about the father's testimony about the kids needing counseling, she totally dismissed his testimony completely. There was no other evidence in the record for her to test the credibility against because the grandfather didn't bring anything in to refute that, and that's his burden of proof. When it comes to the counseling, if you look at the specific language that she used in the order, again, she discounted the father's testimony completely, and she treated it as if his testimony was not sufficient or to be given any weight at all, and that's a problem. In addition to not giving the father's wishes special weight, she also switched the burden of proof, which is a huge error of law. Because parents have constitutional rights with their children and have constitutional rights to decide what's best for their children, when a non-parent wants visitation, the burden of proof is on them according to all the Ohio case law. Yet when it was time to assess the burden of proof, she put it on the father and actually required him to bring in evidence to prove that the kids were negatively affected at school, to prove that the kids' emotional well-being was affected by the grandfather's visitation and that they actually needed counseling. But he doesn't have that burden. The courts have said it is not the parent's job to come and prove that visitation with a grandparent is against the best interest of the child. It's for the grandparent to prove that it actually is in the child's best interest. In this case, she didn't require any evidence.
What specific part of her order are you pointing us to?
Several things, Your Honor. So if we go to T44, for example, at page 3, she specifically discredited Shamel's testimony that the children had to undergo therapy, and she goes, "Father produced no evidence of the children being in therapy." Well, his testimony is evidence. So if she felt it wasn't enough, that's one thing, but she said he produced no evidence at all, which totally 100% ignores his testimony. There is nothing in the law that says a parent's testimony is not accurate or not to be considered unless it's corroborated with something else. There are plenty of cases that I cited in the record where the mother's testimony or the parent's testimony was all there was before the court, and they were able to assess whether visitation was within the best interest of the child. It's illegal for her to 100% not consider his testimony as evidence at all. She can say that she thinks it's not enough, but to say that he presented no evidence is false because he did. He testified. And he's a parent and he knows the best interest of his children. He's the one that took them to therapy every day. So why wouldn't she give his testimony about their need for therapy some credit at all? That's on page 3 of her order, which is in the record at document 144. She did the same thing concerning his testimony about the effect of their living with their grandfather and how it affected their grades at school. She again says the father produced no evidence when his testimony is in fact evidence. She didn't say she didn't think that it was enough. She said he didn't produce any. So basically she didn't consider his testimony as evidence at all, and that's a violation of the law. The father's testimony is supposed to be giving special weight. Based on the own language in her order, she didn't give his testimony about those two things any weight at all. In addition, she further required him. I'm sorry.
The special weight that's to be given is not to the testimony of the parent, but it's to the wishes of the parent. In other words, his wish that the grandfather not be permitted to visit with the children. That's what the trial court is supposed to give special weight to, correct? Not any testimony.
It's the wishes of the parent and the basis for the parent's wishes, like the cases that I cited in the record. The mother said, I don't want the grandparent to have visitation, and then she gave a laundry list of reasons about why she didn't want the grandparent to have the visitation. And the Ohio Appellate Court said that those reasons should have been given special weight. You can't just come to court and say, I don't want the grandparent or the non-parent to have visitation without a basis. And so I feel like it's semantics, Your Honor, to try to separate the father's wish from the basis for the wishes. And I feel like the testimony explains to the court so they can get an understanding of why they have those wishes and give them the special weight and full consideration they're required under the Constitution. Any further questions before I move on to the manifest weight of the evidence argument?
No, and you have about a minute and a half left if you want to reserve 5.
Thank you, Your Honor. So I want to go to the manifest weight of the evidence, and I want to point out several key things, factual findings that she made that were against the manifest weight. The first one being, she said that there was nothing in the record to show that there were any concerns about the children's being in the grandfather's care. That's not true. The grandmother testified that she had several concerns about them being in the grandfather's care, including him calling her out her name and cussing repeatedly in front of the children, including him letting a random stranger get in the car with the kids, and including him not letting them leave the basement and come upstairs to play. She also made a factual finding that there were specific concerns about the father and the kids being in his care, which is against the evidence. Specifically, all of the witnesses testified they had no concerns about the kids being in the father's care. The biological mother even reported to Children and Family Services that she had no concerns about the kids being in the father's care. And last but certainly not least, the agency charged with investigating the abuse said they have no concerns about the kids being in the father's care. So there's nothing in the record to support the juvenile court's factual finding that there were concerns about the kids being in the father's care. It's not there. Thank you, Your Honor.
Thank you, and you are at your time.
Thank you.
All right, you'll have 5 minutes when you return. Mr. Sims, you have 15 minutes.
Good morning. I have been involved in this case for about 20 years, so I'm quite familiar with the parties that are engaged in this case. I would point out to the court, and I think the court has already drawn attention to the fact, and I'm going to read it directly from the decision in this matter, is on the judge's entry on the 3rd page, 2nd paragraph. The court does not find father's witnesses in this trial to be credible. Father acknowledged a certain series of injuries to the children did exist. And I think that she went on to examine the total record in this case because there was an allegation of abuse that one of the children had made regarding the father. As a result of vindictiveness, father stopped grandfather from being able to see the children. This is a case where a grandfather had picked the children up every day after school, had an ongoing relationship with these kids. So in terms of what the court looked at in considering
What about Ms. Bailey's point that, the court says a couple different times, father presented no evidence, but it's true that he presented some evidence. So what do we do with that?
You have to look at it as to the credibility and the weight of the evidence, which is what she was arguing. In this particular instance, I think the court is quite aware. If you're arguing that their grades have failed since they've been seeing grandfather, and he's been picking them up for the last 3 years, well, certainly you would be able to get their report cards to substantiate your claims. If the children were in counseling at that particular point, you certainly would be able to.
But then that gets back to her point that the court was flipping the burden. Why would he have to present additional evidence to substantiate they were in
Because
therapy?
he didn't appear credible. And I think that if you have a witness that's not credible, then you look for more to try to make them credible. In this particular instance, the ongoing testimony was not credible. Now, certainly, if you find my testimony not credible, and I have documentation to support, it changes the demeanor of the credibility, not the weight of the evidence. So I think that once you make that determination that somebody is not credible, then unfortunately, they have to show that they are. And in this particular case, father was unable to do that. But most
But
important,
that's kind of a chicken and egg. Like, how do they know they have to do that before they walk into the hearing?
well, it's not a question of how do they know they have to do that. It's a question of if you come to court and present yourself as a credible witness, then you don't have that same problem. But as the judge, I can make that judgment as to that determination as to whether or not you're credible or not. Now, if I make that determination that you're not credible, right, then there's a million things that I could go back and do to substantiate and make it appear that I'm credible. If I didn't do those things, then you're stuck with the finding that whatever you said or whatever you alleged is not credible. So I don't think it's a question of going back. It's kind of like the chicken and the egg. How do you prepare your case for trial? If you have a witness that is not credible, then
Mr.
you-
Sims, do you need to take a minute?
I'm okay.
Okay.
If your witness is not credible, then they're not credible, period. Now, the other thing is, in terms of the weight of the father's desires in this case, I think that there was deference given to his desires. They just didn't outweigh the best interests of the kids when she went through the statute to term 3109.051, and she made the determination that because of the ongoing relationship that the grandfather had with the kids, that it was important to sustain that in their best interest. I think that the judge in this case considered all the factors that were appropriate. She used the evidence that was presented to her, and she presented it in a manner that supported visitation for the father, grandfather in this case.
Did the trial court give special consideration to the father's wishes?
I think absolutely, because on this page, as you see here, she specifically addressed the father and what he wanted, and the father's testimony was one that she specifically took out, even though there were other witnesses, and addressed. So yes, she did consider his desire to not have the visitation, and she found that it didn't outweigh the best interest of the children to continue that visitation with the grandfather in this case. So, in a nutshell, I think that she did consider the factors that were appropriate under law, and she made a determination that maybe you don't agree with, but she followed the law and she had the authority to do it. It was not an abuse of discretion, and it was not against the manifest weight of the evidence once she made her credibility findings in this case.
Thank you.
Thank you.
Ms. Bailey, you have 5 minutes remaining.
Thank you, Your Honors. I just want to go back and clarify what the law requires. Parents have a constitutional and fundamental right to make decisions regarding the care, custody, and control of their children. But not only do they have the constitutional right, they come into this court with the presumption that fit parents determine the best interest of their children. So this isn't a situation where she's supposed to be weighing the father's credibility against nothing. He's supposed to come in with a presumption of credibility, and then she needs to put the burden of proof.
And again, maybe I'm quibbling with you again with the language. What she's required to do is to give his wishes special consideration. Whether he's credible or not, if he comes into court and says, I do not want my children to be in the presence of their grandfather, that's not a credibility determination. She needs to take that as true and give it special consideration. After that, then we maybe get into credibility, but that is, if his wishes are that he doesn't want to see his children to see the grandfather, the court has to give that special consideration, right?
They do, but what they also have to do is, in addition to him saying, I don't want the grandfather to see the child, when he sets forth what he believes is in his kid's best interest, the court says that he's supposed to get a presumption that he knows best. She didn't do that either. In addition, she didn't require the grandfather to do anything. He came to court without any witnesses, and she totally ignored all the evidence that shows that he lied. He filed an emergency motion and said that the kids were in imminent danger, and then the emergency motion got denied because there was no imminent danger. He testified that the incident that he said occurred happened 9 months prior. He also testified repeatedly that he felt that the father physically abused the children, but when he got emergency custody, he turned around and gave the kids right back to the father and put them in their care. She totally ignored that. Her findings were against the manifest weight of the evidence. All the witnesses testified in favor of the father, testified what the kids' best interest was, is that they had a great relationship with their father. They all testified that the grandfather had a propensity to lie, and all of that stuff got ignored, including Children and Family Services. So I asked the court to go back and look at the specific language in her order. It becomes clear. She gave the father's testimony no weight at all. She ignored it and said that it wasn't evidence at all. Didn't require the grandfather to come into court with anything to show the visitation was in the child's best interest. He just came in and said, I want the kids.
If we agree with you, what would the result be? Would we
The result-
remand it for the trial court to reconsider these things in light of the standard that you're positing, or would we do something else?
No, Your Honor, my ask is that you reverse the decision and that you deny the petition for grandparent visitation. My client shouldn't have to have a trial twice. The witnesses testified, he testified, the record is clear. It affected their schooling, it's not in the best interest, and the evidence shows that the grandfather lied. He shouldn't have to go through that all over again because the juvenile court didn't do its job. We asked for it to be reversed and that the grandfather's petition be denied as a matter of law. Thank you. Any further questions? Thank you for your time.
Thank you both for your arguments this morning. We will take this case under submission and give you a timely written opinion.
Thank you.
Thank you very much. The next case on our docket this morning, and I'll give everybody a chance to take their time and pack up their things. We're in no rush, so take your time. The next case will be State of Ohio versus Montgomery. Ms. Gieske is here on behalf of appellant. Ms. Daniel is here on behalf of appellee. Ms. Gieske, you will have 15 minutes this morning. Would you like to reserve any of that time?
Yes, I would like to reserve 3 minutes, Your Honor.
All right.
Thank you.
Whenever you're ready.
Okay, good morning. May it please the court, Ms. Daniel. The crux of this case is whether Mr. Montgomery was subjected to custodial interrogation such that Miranda warnings were required before questioning him. And I think the strongest and simplest argument here is the fact that the officers and his own body camera had determined they were going to arrest Mr. Montgomery for domestic violence before he ever arrived.
Let me stop you there.
Sure.
isn't it equally as true that the subjective intent of the officer is not determinative? That rather the trial court had to look at what a reasonable person in your client's position would have believed about custody?
I actually think that those are two separate arguments and separate potential bases for reversal. So I think, and I'm not sure if the Ohio Supreme Court has addressed this or not, so it might be a novel argument, but I think that once the probable cause has been developed that someone is going to be arrested, that is when the need for Miranda warnings attaches.
Well, and so that was the point, building off Judge Meyer's question, that I was curious about, because that's what you seem to be arguing in the brief, which is, like, even if the person is not in custody at that point, that because the officers had already made a determination that they were going to arrest him, you can't kind of skirt the custody requirement and then just like start asking questions, get incriminating responses, and then arrest. But my question is, like, I haven't seen authority that would support that, so I was curious if you'd found something.
No.
Okay.
So correct, that would be a proposition of law that I would advance that, like I said, could be novel. I haven't not researched it since I wrote the brief, and I have not gone outside of Ohio. So I don't know how other states handle this. That would be, again, a prop of law that I would say that once definitive probable cause has been developed, that the need for the advisements attaches. So that would be one argument. The fact...
But, and let me just ask you about that, because, I mean, he was being questioned on the domestic violence incident, and even though they had probable cause to arrest him at that point, and I realize that you made the argument about the standard, but, like, is it incumbent upon the police to arrest before they hear the other side of the story?
So that's where I think, sorry, were you done?
No, yeah, go ahead.
That's where I think the preferred arrest statute is helpful in the context of, I'm just going to say DV because it's faster, DV and CPOs, because that statute dictates, I guess that's not the right word, says that the preferred course of action is to arrest the suspect immediately, and if there is a factual question as to primary aggressor, then there's a need to question further. And here there was not. That factual question didn't exist. I would also argue that that is where the Cincinnati Police Department policy manual, where their standard policy also factors into the assessment, because trial counsel did present evidence, and I think he even appended the section to one of his filings, I know he did, that it says that a domestic violence suspect is to be immediately arrested. That was the word the policy used, was immediate. So when you factor in CPD policy and procedure, the preferred arrest statute, when you factor both of those in, those counsel in favor of, yes, that the suspect should be immediately arrested. And again, I think it is separate and apart from the typical custodial interrogation analysis. And I actually think that one of the cases cited by the trial court out of the fifth, that would be the Farrell case, should have counseled in favor of granting the motion to suppress, because in Farrell, there was this dispute in a gas station, I think, parking lot. This couple they were fighting loudly. The person was afraid it was going to be a DV. So the person called in, the officer arrived, and when he arrived and he made contact with the defendant, he did smell alcohol. The indicia of intoxication were present. So that is what the Miranda decision would have contemplated as general on-the-scene questioning. The person was not going to be arrested. Probable cause had not been developed when they arrived. He began questioning. He made contact. He thought, there is no DV yet, whether there was or not. Probable cause had not been developed, at most suspicion. And then the OVI indicia crept up pretty immediately. I think that is what Miranda contemplated as general on-the-scene questioning. Versus here, the officers did, again, on camera, we're going to arrest him. Hey, it's going to be a felony because he has a prior. So definitive probable cause. He gets on scene. They question him immediately about the DV. And then they suspect OVI. It creeps in. But What I'm not saying,
But didn't the, wasn't the questioning about the domestic violence incident, and he then volunteered, oh yeah, we were drinking a lot, and that's why I don't remember the details. Am I remembering?
you are remembering correctly,
transcript
and
correctly?
that, you know, that is part of, so the purpose of Miranda is in situations that could be, you know, the Fourth, Fifth, and Sixth Amendment are designed to inhibit undue government influence and control. So Miranda is a safeguard. It says that under circumstances that could give rise to coercion, so when police are involved, especially in number or on scene like here, that person needs to be advised immediately when they are a suspect, before, or at least when, before custodial interrogation takes place, to protect them from inadvertently saying things without being aware, like, okay, I have a right to not say anything. I have a right to an attorney if I do, et cetera, et cetera.
Here, didn't the court consider all the factors that it was supposed to consider?
So the court did consider, and I don't know if this court has formally adopted the Second District's S-step factors yet, but they're good.
We're aware it exists,
Yes.
so I'm not sure we have either.
Right. So, but it's a good set of, I think it's 10 factors. So what was kind of, I thought, odd was the trial court did consider those factors, and at the end of the suppression hearing said, yeah, those seemed to counsel in favor of the defendant, and then took time and got post-argument briefs, and then decided the case the other way. So I'm not going to, waste the time going through the S-step factors, but to be fair, about half of them counsel in favor of my client, a couple are neutral, and 4, I think, are in favor of the state. So I would still say that is a closer call. I think that the novel argument advanced, the probable cause argument, is a cleaner way to deal with the case, but we would still argue that.
But boy, aren't there a lot of cases out there where there's probable cause, even in serious cases like murder, and I don't have those cites at hand, but where the court determines the person is not in custody, even though there might be probable cause to arrest her, because she's free to leave, and in fact, in many cases, does leave. Are you suggesting that in those cases where somebody's free to leave and does leave, that if there is probable cause, that Miranda's implicated?
I would advise, and I appreciate that in the moment, these cases are A, very fact-specific, and B, police officers have to decide Fourth Amendment questions like that very quick, so it's tough. I would advise that because our constitutional rights are so important, to err on that side of caution. We're not saying you can't question. All we're saying is that you have to Mirandize, that it is that important that the person be aware of their rights in the moment. When something becomes, and again, it's general questioning, no, there's no need to Mirandize. If you're just starting to investigate, no. But once someone is in custody, they're not free to leave. Yes, that we would argue that yes, that the need to administer Miranda attaches.
But what if they are free to leave? There's still probable cause to arrest them, but they're free to leave, and they do leave.
If there's evidence in the record, and I don't think you're going to get this as often, that the police, law enforcement commemorates, we are going to arrest this person. It doesn't happen very often that it is articulated on the record, that they definitively say that before someone comes. So we know that that person was not free to leave. Mr. Montgomery was never going to be free to leave. So probably the argument about the probable cause and custodial interrogation, they probably do overlap. I guess there are going to be instances where they have probable cause, but for whatever reason they let the person go. But that's going to have to be in the record. So I think I would have a much harder road to hoe here if the officers did not say prior, commemorated on body camera, we're going to arrest this guy. But they did. So under those circumstances, again, we are just advocating for erring on the side of, police investigations can continue. They must continue. But when it switches over from this general questioning to this person is not going anywhere, they need to administer Miranda. And what is the only reason not to? The reason not to is to get the person to keep talking, because Miranda can have a chilling effect. And that is what we're trying to guard against, that undue curbing of the rights. So if there are no further questions, I'll just reserve the remainder of my time.
All right, and you will have 5 minutes
Okay,
remaining.
thank you.
Ms. Daniel, you have 15 minutes.
May it please the court, opposing counsel. My name is Amber Daniel, and I'm here for the City of Cincinnati today. Your Honors, the first portion of my argument will be the State v. Farrell case. We heard a lot of argument already on the State v. Farrell case, and we view this a little bit differently. We view the same way that the court viewed, that this should be the case that, I know it's not within our district, but we believe that this should be the persuasive law in this. Upon the arrival, officers found the defendant sitting in a parked car. Defendant admitted that he had just been in a fight with his girlfriend, but officers also saw signs of impairment. After conclusion of this, the officers asked the defendant to complete sobriety tests. Defendant performed poorly, and then at that point, he was arrested. I believe that this case is just like our case at hand. Officers did receive a domestic violence call in our case at hand. They went and started investigating the domestic violence call, but they weren't done with their investigation at that point. They received a phone call in the Farrell case for domestic violence. They went and started to do the domestic violence examination. Once they got there, they saw some signs of impairment. That's the same as in this situation. As soon as Mr. Montgomery arrived, there were some signs of impairment that they saw at that point. And in that, they actually found that in the Farrell case, that they didn't have to Mirandize him at the immediate moment, that nothing had to be suppressed at that time, because there was still a continuing investigation. Just like in our case, there was a continuing investigation.
But I think getting back to Ms. Gieske's points, like once there was a continuing investigation, but the officers had concluded that they were going to arrest him, and at that point, should they Mirandize him if they know they're going to arrest him? Like, set aside whether it's custodial interrogation or not, but at that point, anything he says or does will be used against him, and should he know that?
So our argument in this is that when he arrived, that even though they did have probable cause at that point and they were going to arrest him, if he would have came and there were signs that he was not the primary aggressor, that she had actually done something, if they saw some kind of marks on him, if they heard something that would have negated what she said, they wouldn't have arrested him at that point, because there would have no longer been probable cause to arrest him. So we believe that they do need to look at both sides, both parties, because otherwise we're going to have a lot of arrests that we don't actually need to have happen. So we believe that you need to look at both sides before you actually make an arrest, and that's what our argument is here, and that's what we believe the officers.
So in other words, what you're
doing.
saying is, even though they had technically had probable cause, like their investigation wouldn't be complete until they talked to the other party, and maybe then they reevaluate probable cause based on what he says.
Right. So we believe that just because they had probable cause, that's probable cause listening to one side of the story. There could have been a totally independent witness. There could have been anything that came up at that point and took away that probable cause and made it.
Did they
to
ask
where
him
there
any
wasn't that.
questions specific to the drinking before he acknowledged the consumption?
No, Your Honor. So they only spoke to him about the domestic violence, and then he offered at that point the admissions to drinking, and then they noticed the different factors and stuff that they noticed as well. As soon as he pulled up, they noticed that he came over there and that he was limping and kind of swaying when he came over there, that he scraped his tires, that he smelled of alcohol. So they noticed the different things but did not ask him about the OVI. He admitted to the factors of that. So that would be our argument. Our argument was that he was not in custody. He was at his house. He walked up to them freely. He was speaking as much as they were. I know that you guys probably didn't see the body-worn camera, but he was speaking equally as much as they were and was addressing things and admitting to things without them actually asking him anything. There was no show of intimidation. I know that in the brief there was a lot of discussion from opposing counsel of a noticeable barrier, but I don't believe that there was a noticeable barrier. There were two officers. They weren't positioned in a way that would have made him feel like he couldn't leave. And at all points of this, I believe that a reasonable person would have felt like they could have left, as they never said anything or did anything that would have intimidated him at that time. And that's our argument, is that preferred arrest, that is the preferred arrest statute, but just because it's the preferred arrest statute doesn't mean that that's what they have to do. I think when the lawmakers made that statute, they went in knowing that there are some circumstances that, even though this is the preferred method, that's why it's not the mandatory method, because there's going to be some circumstances where when they see what's going on, they're not going to end up arresting that person. That would be just like a lot of times when officers are called. If the defendant and the prosecuting witness are there, the defendant is not immediately going to be arrested just because there was a 911 call that something happened. They're going to listen to both sides of the story. A lot of times one officer will talk to one person, the other officer will talk to the other person, and then they'll make a decision at that point. So that is what we are arguing is happening here, that he might have arrived later, but they had to listen to both sides of the argument before, or both sides of the incident of what happened before they actually made the decision that they were fully going to arrest him. Even though they had probable cause, and even though they had made that decision, it could have changed based on what he was saying. So if there are no further questions, I would submit it on briefs at this point.
All right, thank you. Ms. Gieske, you have 5 minutes remaining. Let me start by asking you something. Didn't the officer say, and I'm paraphrasing now, that based on the information we had before he arrived, we had probable cause to arrest him, but we wanted to talk with him to determine whether or not there really was probable cause because we wanted to hear the other side of the story, and our probable cause may have evaporated after we talked to him.
So my recollection of when the officer tried to walk back a bit was not quite that he said, because I didn't think it made sense, it struck me so strange. We had probable cause to arrest. He got there. Then we had reasonable suspicion. You know, like it can't downgrade itself. So I think that was an attempt to walk back. I don't recall it. Again, I didn't go back and read the exact wording though, before argument. So, and I'm not sure if.
Well, and I think, like, from the perspective of your office, like, do you really want officers arresting on trigger determinations just listening to one side? Like, I think that would be bad for your clients overall.
True, and yes, and I think that is what is baked into the preferred arrest statute is if there are circumstances where you don't know who the primary aggressor is, you know, it's advocating for getting both sides. But contrary to what opposing counsel is suggesting, I think if you say that's what these officers were doing, that's not supported by the record. So if you say, no, they were sussing out the primary aggressor, they were trying to get both sides, I think you're actually adding to the record because that is not what they say. The officers are talking, I think it's by the cruiser before Mr. Montgomery arrives. And they say, yes, we're going to arrest. Some of it's hard to hear at that point. They say, yes, we're going to arrest him. Yes, he's got a prior, so it's going to be a felony. There's no, let's get his side. They don't even know he's going to come yet. They just make that determination, yes, we're going to arrest him. Would it be the best practice to get the other side? Yes, but that is not what we have here. That would be adding to the record to try to get into their minds and say, that's what they were doing here, because that's what a good officer would do. That's not what they said.
What about, like, from the OVI context, if a police officer sees a car swerving and acts like pulls him over and rolls down the window and the guy's slurring his speech, and then the officer says, were you drinking tonight? Mm-hmm. Does the officer need to Mirandize the person before asking that question?
That's going to be hard to, again, these are so fact-specific. I think the moment they know they're going to arrest someone, and that's not going to often be very clear from the record like we have here. The moment they know that person's not going anywhere, they are under arrest, yes. You have to Mirandize at that moment. And here, I don't want to, like I said, I don't want to waste time combing through all the STAP and the facts, but just to correct one of counsel's misstatements, there were 3 officers, so it wasn't 2. I know you guys watch the body cams, and that there are 3 if you look, and so Mr. Montgomery's even surprised. He makes a joke. He's trying to dispel the tension. Some of these observations just...
But doesn't that weigh in favor of he didn't feel like he was in custody? A reasonable person wouldn't have felt in custody?
I don't think
if he can joke with the officers and...
I don't think so, because a lot of people use humor to dispel tension. That's a common tactic. And a lot of people are immediately nervous with police around, period. And, you know, especially he is a black man in the dead of night. There are cruisers around. Their lights are activated. It's pitch black out. And to that end, some of the observations, this is why video evidence is so definitive. The swaying and slurring, that's not borne out by the body cam. So the scraping of the tires, he says he saw it, and it's across the street. There are other cars in the way. It just is not borne out by the record if you want to do that factual analysis, but I don't want to get too far into that because I do, again, think that the crux of this case is once you know you're going to arrest someone, their constitutional rights have to be upheld and protected. You have to Mirandize. So that would be the prop of law that I would advance in this case. And if you want, you can dovetail in the custodial interrogation analysis because he was not going anywhere. If there are no further questions, I will ask that the court reverse and order that the trial court grant the motion to suppress.
Thank you.
Thank you.
Thank you both very much for your arguments this morning. We will take the case under submission, give you a timely written opinion. That will conclude our oral arguments this morning for the First District Court of Appeals.